Good day, ma'am. My name is Angelico J. Padua, section of OLSA 22E21, subject of CPC-LJT. Today, I would recite the following question. Number 1. What is a burden of proof? Burden of proof, also called burden of persuasion or onus probandi, is the duty of a party to present evidence on the facts in issue necessary to establish his claim or defense by the amount of evidence required by law. Number 2, what is burden of evidence? Burden of evidence, also known or also called as onus eventiae, is the burden of going forward with the evidence. Number 3, what is evidence difference between burden of proof and burden of evidence? Burden of proof never shifts and it remains with the party upon whom it is imposed, while burden of evidence shifts from party to party depending upon the existence of the case in the course of the trial. Number 4, what is meant by presumption? Presumption is a rule of law stating that because of basic fact exists, another fact also exists. It is an inference as to the existence of a fact not actually known, or conjecture based on past experience as to what course human affairs ordinarily take. Number 5, what are the two classes of presumption? Number 1, presumption juris or presumption of law. Number 2, presumption hominis or presumption of fact. Number 6, what are the two basic types of legal presumption? Number 1, conclusive presumption, Rule 131, Section number 2. Number 2, disputable presumption, Rule 131, Section 3. And question number 7, give two examples of conclusive presumption. Number 1 example, whenever a party has by his own declaration, act or omission intentionally and deliberately lead to another to believe a particular thing true, and to act upon such belief he cannot any litigation arising out of such declaration, act or omission be permitted to falsify it, also known as estoppel in pais or equitable estoppel. Question number 8. Example number 2, the tenant is not permitted to deny the title of his landlord at the time of enforcement of the relation of landlord and tenant between them, also known estoppel tenant. Question number 8. Give at least 10 examples of disputable presumption. Number 1 example, that a person is innocent of a crime or wrong. Number 2, that an unlawful act was done with unlawful intent. Number 3, that a person intends the ordinary consequence of his voluntary act. Number 4, that a person takes ordinary care of his concern. Number 6. And number 5, that evidence willfully suppressed will be adverse if produced. Number 6. Number 6, that money paid by one to another was due to the latter. Number 7, that a thing delivered by one to another belonged to the latter. Number 8, that an obligation delivered up to the debtor has been paid. Number 9, that prior rents or installment had been paid when a receipt for the later was produced. Number 10, that a person acting in public office was regularly appointed or elected to it. Question number 9. Who can contest the legitimacy of a child born to a wife? No presumption of legitimacy of child born after their 100 days following the dissolution of the marriage, of the separation of the spouse, wherever alleged the legitimacy of such child must prove his allegation. Question number 10. What is the doctrine of res ipsa loquitur? State the requisite for the doctrine to apply. Res ipsa equator is a Latin phrase which literally means the thing or the transaction speaks for itself. That's all, ma'am. Thank you.